Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about an unusual step that the Supreme Court of the United States took yesterday with respect to an application for a stay in the Purdue Pharmacy bankruptcy case. And it's important because instead of requiring an actual petition for certiorari, which is the normal process, they acted on the application for a stay and they granted the stay and they took it as a writ of certiorari and they told the parties you have to have this briefed so that it can be argued in December of 2023, December of this year, which when you think about it, it's only 4 months away. So there's going to be an oral argument fairly quickly in this case. So what's this all about? Well, in order to understand what this is all about, we need to go back a little bit in history. OxyContin first came into the public sphere in 1996, and when it did, it was manufactured by a company called Purdue Pharma. And Purdue Pharma was pretty much, for at least initially, the only seller of OxyContin and exceptionally strong opioids. So they marketed and pushed this drug for a number of reasons. They especially said that it really wasn't as addictive as other opioids, when in fact it was actually more addictive. So in the years that followed, Purdue Pharma made $35 billion, with a B, $35 billion on OxyContin. And Purdue Pharma was owned and held primarily by the Sackler family. And the Sackler family was doing pretty good. They were sitting in tall cotton, as they say down here in the South. And as a result of that, they thought they would probably continue until the first of the opioid lawsuits began. And the opioid lawsuits essentially took the same track that the tobacco lawsuits did, saying these people know that they are pushing a dangerous product, they know that it's addictive, and they're not warning about it. And the lawsuits quickly began to pile up, first from individual plaintiffs and then from states and counties and municipalities who had seen their costs increase astronomically for taking care of all of these indigent people and drug-addicted people who came down with opioid dependency. Between 1999 and 2019, in that 20-year period, over 250,000 people, more than 250,000 people, died from opioid overdoses, prescription opioid overdoses. So the feds took them to court, and twice they pleaded guilty to criminal charges in 2007 and again in 2020. But that didn't stop the bleeding for Purdue Pharma. And as I said, it was the target of numerous lawsuits by private plaintiffs. So in 2019, in order to shield the company from all of these lawsuits, Purdue Pharma filed for bankruptcy. And the Sackler family, that had withdrawn about $11 billion out of the company before it went into bankruptcy, was instrumental in whether or not the bankruptcy could be completed, because they pretty much held controlling interest in the company. So a lot of the private plaintiffs that had sued Purdue Pharma had also sued the Sacklers. And they'd sued them because they essentially, they basically looked at the Sacklers as drug dealers, as people who knew they were selling a addictive product and were intending to profit as much as they possibly could from it. So in order for this bankruptcy to go forward and have a plan that could be confirmed, there had to be money that was put into the company, because it had pretty much been reduced to bankrupt status by virtue of the lawsuits and having to defend all of the lawsuits. Somebody had to put some money into the company in order to fund the reorganization plan. And the reorganization plan basically said, we're going to take Purdue Pharma and we are going to convert it into a not-for-profit, and we are going to fund a lot of opioid and addiction abatement kinds of programs. So the Sacklers, as a family, decided to contribute $4.5 billion into Purdue Pharma to help the plan get confirmed. But there was a but, and it was a big but. And the big but was, in order for you to get this $4.5 billion, everybody who has a claim against the Sacklers and everybody who has a potential claim against the Sacklers has to agree that it is released in this bankruptcy, released and extinguished as a part of this bankruptcy reorganization plan. So let's think about what they're actually saying here. What they're saying is that they are non-debtors. The Sacklers did not file personally for bankruptcy protection. They couldn't. They were sitting on at least $4.5 billion. The company filed for bankruptcy, but the company is not the Sacklers. The Sacklers are individuals. They are people with private interests that are separate and apart from Purdue Pharma. They wanted a release of all potential claims against them in order to fund part of the bankruptcy. Now, the U.S. trustee opposed this plan, but as a result of some very good lawyering by the people in the Purdue Pharma that represented Purdue Pharma in the bankruptcy, they got it past the bankruptcy judge, and the bankruptcy judge issued his opinion confirming the plan. Ordinarily, that's pretty much the end of it, but in this case, the U.S. trustee appealed that decision to the district court judge in New York. And the district court judge looked at this and saw people who had taken $11 billion out, given $4 billion back, and getting a release. And other than giving the money to the company, they had done nothing for the people who were suing them. And he decided that the bankruptcy plan should not be confirmed. So he reversed the bankruptcy court. So Purdue Pharma, with its hair on fire, went to the Second Circuit and begged, pleaded, cajoled, whined, whatever you want to say. They got the Second Circuit to reverse the district court and put the bankruptcy plan back into effect. So the U.S. trustee wanted to appeal that. They went through the Solicitor General's office and they filed this application for a stay. And then every Tom, Dick, and Harry who was getting money under this plan began filing all kinds of objections to the Supreme Court issuing a stay. And I'll show you just a few of them here. This is the response in opposition to the filing for a writ of certiorari and stay, and it's filed by Ad Hoc Committee of Governmental and Other Contingent Litigation Claimants, the Ad Hoc Committee, and they oppose it for a number of things, but the main reason is it would essentially delay payments to their creditors, which they don't want to see happen. In fact, this is pretty much what most of the people say when it comes right down to why they want to oppose it. And this is a brief in opposition filed by the Multi-State Governmental Entities Group, and that is a group of about 1,300 cities, counties, tribal nations, hospital districts, and independent school districts that were claimants in the bankruptcy. And what do they say? In his application, the trustee, who has no economic stake in the debtors' Chapter 11 reorganization and no claims released under the plan, demands a stay that will further delay the distribution of billions of dollars of critically needed funds to opioid creditors while he fights to advance a minority interpretation of the bankruptcy code. And by minority interpretation, what he means is that some of the circuit courts of appeal do not allow third-party releases, but the majority of the circuit courts do allow third-party releases. So one of the things that they talk about, and you'll see this a lot in the bankruptcy cases, is that after 2 years of intensive negotiations and mediations, numerous settlements of complex disputes were achieved and formed the basis for the plan. A lot of times what the lawyers do is they champion the plan because the plan is what gives everybody money. But at the end of the day, what these folks are really interested in is getting the money. Purdue Pharma itself, the table of authorities gives you some idea of what they're arguing. There was a tidal wave of litigation against the debtors. They invoked this comprehensive resolution, including releases of certain claims against the Sacklers, and it had almost universal support, which means everybody took a hit in it. The plan embodied the global settlement as filed, received support from 95% of the voting creditors. Again, you have to be careful in looking at that because the 95% of voting creditors who voted may not actually be the full 95% of people who have claims against the Sacklers. Some of them may not be before the bankruptcy court because they did not want to go after Purdue Pharma. They wanted to go after the Sacklers. Challenge to the plan in the Second Circuit decision ordering confirmation. There is no reasonable probability that this court will grant certiorari. Well, obviously they were wrong about that. There's no split on whether third-party releases are categorically barred in the circumstances here. No, there's no split with regard to third-party releases being categorically barred in the circumstances here, but there is a split with regard to third-party releases. The case is a singularly poor vehicle for review. That's absolutely untrue because it's such a huge bankruptcy, and the weight of the difference between what the Sacklers took out and what the pittance that they're willing to put back in is a fairly important concern. There is no fair prospect for reversal. Again, not true. If I was sitting on the Supreme Court, I would reverse this in a Cincinnati second. The trustee has not shown irreparable harm. Actually, in a situation like this, with equitable mootness being the way it is, there's a theory that you can't unscramble the egg. And so what the trustee is trying to do is keep the egg from being scrambled in the first place. This is the reply of the trustee, who is William K. Harrington, and he raises a couple of interesting points. He said the court should have the opportunity to resolve a long-standing disagreement in the circuits and decide whether the sweeping release of claims against the Sacklers and others is lawful. And then he talks about what the other parties do. They don't disclaim a litigation strategy of invoking equitable mootness to keep the partly effectuated plan in place, regardless of its ultimate legality. As you all know, I have done a video on equitable mootness, which is neither equitable nor truly is it mootness, and hopefully the court will answer some questions about that in this case too. No respondent opposes the U.S. trustee's suggestion that the court construe the stay application as a petition for a writ of certiorari. Basically what they do is they spend a substantial portion of their filings urging the court to deny certiorari. Some of them contest that the U.S. trustee has standing, but Congress validly authorized the U.S. trustee as a representative of the United States to oppose the plan on the ground that it is unlawful. The government's also likely to succeed on the merits. The plan proponents invoke residual bankruptcy code provisions as the foothold for an extraordinary authority for bankruptcy courts to dictate relations between non-debtors and other non-debtors who are outside the bankruptcy system. The Court of Appeals approved a release that extends to fraud-based claims that the Sacklers could not have had discharged even if they had submitted to the bankruptcy court and thereby surrendered their assets. The balance of the equities also supports a recall and stay of the court's mandate. Now, this is just the introduction, but basically these are the arguments that are repeated in that reply. Pretty much all of these say the same thing. Basically, in order to get this money, you have to let this plan go through. So the Supreme Court did a really wise thing. They said, okay, we're going to grant the stay. We are going to stop the confirmation process in the Purdue case. We're going to hold an oral argument in this case, and we're going to decide whether or not these releases are kosher or not. But we're going to do it on an expedited basis. You have to get this briefed and ready to argue by December of 2023. And in that way, there will be a much shorter delay in getting this money to the victims if indeed they decide to approve this concept. Now, why shouldn't they approve this concept? Well, there's this little thing called due process. Due process of law says that if you have if you've been wronged, you should have a remedy. Wherever there's a right, there should be a remedy. Now, that doesn't always happen in the law, and in bankruptcy, everybody takes less than they should. But the bottom line is that if somebody is not in bankruptcy, they really should not be subject to the protections of bankruptcy. The protections of bankruptcy protect the debtor, in this case, Purdue Pharma. They do not protect the people who took the money out of Purdue Pharma. And when you cut off, if I'm an opioid claimant and you cut off my ability to go after the chief architects of this marketing plan, the people who profited the most from this, well, in that situation, you are depriving me of due process of law. I do not get the opportunity to go and bring them into court and have them answer for their conduct. Instead, they get a free pass. Well, I guess it's not free. They're paying $4.5 billion for it. But the fact of the matter is that if all of these same people sued the Sacklers, they would wind up having to come into bankruptcy court too. And if they did that, then probably the people who are getting the money might get roughly the same amount. But they also might very well get more because the Sacklers probably have a lot more money to give in a bankruptcy than $4.5 billion. Generally speaking, $4.5 billion may be to the Sackler family much like paying a parking ticket is to you and me. The fact of the matter is that a non-debtor, in this case the Sacklers, releasing claims against them as part of a bankruptcy involving only them peripherally. In other words, they're not directly involved in the bankruptcy. They aren't protected by the bankruptcy stay. Allowing them to take the benefit of bankruptcy without the burden of bankruptcy is fundamentally wrong. And that's why the U.S. government pursued them. That's why the U.S. trustee pursued them. And that's why all of this nonsense about the U.S. trustee being a rogue agent is just so much baloney. And believe me, with a name like Tony, I know a lot about baloney. It was half my life. That's what they called me. At any rate, I think it's funny that in this particular situation, Purdue Pharma is essentially advocating on behalf of the Sacklers under the guise of advocating for the victims. And I think, I would hope that the SCOTUS is able to see the real picture here. Several days ago, I did a video and I talked about Narcan. Narcan is now available as a non-prescription nasal spray that can be used to reverse an opioid overdose. This is a really good thing. Anyone who has a loved one who has an opioid addiction problem, or an addiction problem even with something like heroin, Narcan is an essential drug to keep handy. Because even if somebody is in treatment, even if they're in therapy, even if they are making good progress in therapy, relapses happen. Things happen that cause people to go back on those drugs, and a lot of times they go back to using at the old level when their body has deconditioned from it, and they develop a fatal overdose as a result. Please remember that this is a life-saving drug that you do not need a prescription to buy and that can save a life. And again, I'm not trying to sell this for whoever makes Narcan. I'm simply telling you it's a very wise first aid resource to keep on hand. So that's what I have for you today. Thank you very much for watching. Have a terrific day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.